Phil Twyford.
Thank you, Mr Speaker. I'm very happy to take a call in support of the Register of Pecuniary Interests of Judges Bill brought to this House by the Honourable Member Dr Kennedy Graham. As members will know, Labor is supporting this bill to Select Committee. It's hard, sir, to argue against a bill that seeks to extend the principle of transparency to any branch of government, and the record of this party in government is one of supporting the advance of open government and transparency, and on the face of it we see no reason why this bill, which seeks to extend transparency to the judiciary, should not at least receive serious consideration at Select Committee. The executive branch of government, as my colleague Phil Goff noted, has been subject to the disclosure of pecuniary interests since 1990, and it was the fifth Labor government, sir, in 2006 that extended the same requirement to all members of Parliament, sir, and that was undoubtedly, now we can see, was undoubtedly a good thing. As previous speakers have observed, the primary benefit that this bill seeks to achieve is the strengthening of confidence in the judiciary through transparency, and this will ensure that where there might be a conflict of interest in a case due to the particular interests of a member of the judiciary, that they can be resolved earlier rather than on a case-by-case basis. And the purpose of the bill, sir, is to promote the due administration of justice by requiring judges to make returns of pecuniary interests, just as Cabinet Ministers and Members of Parliament currently do. And in doing so, sir, that will reduce the potential for perceived conflicts, perceived or real conflicts of interest. The Law Commission, as has been noted, is working on these matters now and will bring a report to Parliament, and that will undoubtedly be of great assistance to the Select Committee as it weighs up these issues. But the Commission has already released an issues paper on this matter as part of efforts to modernise the Judicature Act, and I want to, sir, quote one or two passages from that issues paper. The Commission noted that there are more than 50 tribunals in New Zealand, many of which require a legally qualified tribunal chairperson dealing with a wide range of legal issues. And they asked, why should people exercising at least quasi-judicial powers also not be covered by these kinds of provisions? The Commission also said that the primary question is whether a register of judges' pecuniary interests is necessary or appropriate. And if the answer to this question is yes, then there are a number of other questions that the Select Committee, sir, will have to consider about the scope and requirements of such a register, who it will apply to, what level of detail is required, and how widely available the resulting information should be. So those are all, I think, useful issues that the Commission poses. And previous speakers, sir, have noted the importance of maintaining privacy for those who are covered by such a register, and as is the case with the MP's pecuniary interests declaration, there will be a need, sir, to ensure that the information is presented in a way that does protect the privacy of individuals. The Commission's preliminary view was that no legislative intervention is required to the substantive law relating to recusal for financial interests by a judge, but the process by which recusal applications are entertained in the courts could usefully stand refinement and publication. And the question, sir, is how much detail, what kind of scope is required, and what the cost of those provisions would be in relation to the benefits. And I think the really useful observation made by the Commission, sir, was that the value in transparency is that it increases public confidence in our institutions of government. Labor is supporting this bill to Select Committee.
Call Julianne Gent.